Welcome to Mythos AI, your source for Cliff's Notes on complex subjects. Join Anna and Phil for yet another engaging conversation.
Welcome. If you're looking to get a handle on some really complex current events, well, you're in the right place. We're going to do a deep dive into something pretty major happening right now.
Yes, we're looking at a really significant development. The president openly defying a unanimous Supreme Court order. This isn't just, a political spat. It feels like it could be heading towards a constitutional crisis.
And it all centers on one individual, Kilmar Abrego Garcia, a Maryland resident, deported to El Salvador back in March, even though there was a court order meant to protect him.
That's right. And then just recently, April 10th, the Supreme Court weighed in 9-0, unanimous, telling the administration they need to facilitate his return.
So our goal here today is to really unpack this. What are the facts of Mr. Abrego Garcia's case? How does this defiance fit into, well, American history?
Exactly. We need to look at past instances where presidents and the courts have clashed. And maybe most importantly, what are the potential consequences? For the government, for individual rights. We'll even glance at how things have played out in other countries where judicial independence has been challenged.
Okay, let's start with the basics. The Supreme Court, we talk about its power, but where does that power actually come from?
Fundamentally, it comes down to judicial review. This idea wasn't explicitly spelled out in the Constitution, but it was cemented way back in 1803. The case was Marbury v. Madison.
Chief Justice John Marshall.
Right. Marshall basically argued that if the Constitution limits government power, the courts have to be able to decide when laws or executive actions cross those lines. Otherwise, the limits don't mean much.
So the court gets to say this law is constitutional or this action isn't.
Precisely. Marshall famously said it's emphatically the province and duty of the judicial department to say what the law is. If a law conflicts with the Constitution, well, the Constitution wins. The court can strike down that law. It's a core part of checks and balances.
But the court doesn't have an army or, control the budget.
That's the crucial part. It has no enforcement mechanism of its own. Congress controls the money. The executive branch controls, enforcement power, the military, federal agencies.
So the court's authority really depends on acceptance.
Yeah.
And the president actually doing what the court says.
Yes, exactly. It relies on its own legitimacy being accepted and, critically, on the executive branch being willing to enforce its rulings. History shows us that's not always guaranteed. Even Chief Justice Marshall worried about this when Andrew Jackson ignored a ruling.
Okay, history seems like the right place to go next. This isn't the first time a president has clashed with the court, is it?
Oh, definitely not. While directly defying a unanimous order like this is pretty rare, there's a long history of tension. Friction between the White House and the Supreme Court is almost baked into the system.
So looking back helps us understand how unusual, or maybe usual, the current situation is.
It does. Let's take Andrew Jackson first. His refusal to enforce the Worcester v. Georgia decision is probably the starkest early example of noncompliance.
Right. Worcester v. Georgia, what was that about again?
It was the 1830s. Georgia was trying to impose its laws on Cherokee Nation lands, which went against federal treaties that recognized the Cherokee as, a sovereign entity.
And Samuel Worcester was arrested.
He was a missionary, arrested by Georgia for being on Cherokee land without a state permit. The case went to the Supreme Court, and Chief Justice Marshall ruled in 1832 that the Cherokee Nation was distinct, that Georgia law didn't apply there. They ordered Worcester released.
But Jackson, you didn't step in.
No. Georgia ignored the ruling. Worcester stayed in jail for a while. And President Jackson, who, strongly favored Indian removal policies, he just refused to use federal authority to make Georgia comply.
Isn't that where the famous, maybe legendary quote comes from? John Marshall has made his decision.
Now let him enforce it. Yeah, whether he actually said those exact words is debated, but it certainly reflects his administration's attitude. They essentially argued the president had as much right to interpret the Constitution as the court did.
And the result of that defiance.
Terrible. Worcester was eventually pardoned, but Jackson's administration pushed ahead with removing the Cherokee anyway, ignoring the principles the court laid out. This led directly to the Trail of Tears. Thousands died. So Jackson's inaction let a state defy the court, caused immense suffering, and really weakened the court's standing at the time.
That does sound like a worrying parallel. What other moments should we look at?
Well, jump forward to the Civil War. Abraham Lincoln and ex parte Merryman in 1861. It's a different context, obviously, a national crisis.
Maryland, right? A border state.
Exactly. Crucial for the Union, but lots of Confederate sympathy. Lincoln was trying to keep control, prevent sabotage, so he authorized military commanders to suspend the writ of habeas corpus in some areas.
Habeas corpus.
Yeah.
The right to have a court review your detention.
Yes. You can't just be locked up indefinitely without cause shown. John Merryman was arrested by the military in Maryland for secessionist activities.
And the courts got involved.
Merryman's lawyers went to Chief Justice Roger Taney, who was also acting as a circuit judge. Taney issued the writ, told the military to bring Merryman to court, but the commander refused, citing Lincoln's order.
So Taney ruled against Lincoln.
He did. Taney ruled that only Congress, not the president, could suspend habeas corpus under the Constitution. He said Lincoln had overstepped, violating civil liberties.
And Lincoln's response.
He essentially ignored Taney's ruling, too. He later argued to Congress that the Constitution does allow suspension in rebellion or invasion when public safety demands it, and he felt he had to act fast, especially since Congress wasn't in session. Arrests continued.
So another instance of a president prioritizing, let's say, national security over a judicial order.
Right. Merryman was eventually released, but Lincoln clearly put his interpretation of executive power during wartime above a direct judicial ruling, even from the Chief Justice. It highlights that tension between executive power and civil liberties in a crisis.
These are direct clashes. What about presidents trying to influence the court more indirectly, like FDR?
Yes, Franklin Roosevelt's court packing plan in the 1930s. That was a different kind of confrontation. FDR was deeply frustrated because the Supreme Court kept striking down his New Deal programs, crucial parts of his plan to combat the Great Depression.
He felt the court was obstructionist, stuck in the past.
Exactly. He saw the conservative justices as blocking necessary reforms. So, in 1937, he proposed legislation. It would let him appoint an extra federal judge, including on the Supreme Court, for every sitting justice over 70 who didn't retire.
Which would have allowed him to add potentially 6 new justices to the Supreme Court.
Potentially, yes. Up to 15 total. He framed it as helping an overworked aging court, but everyone saw the political goal: create a liberal majority favorable to the New Deal.
I imagine that didn't go over well.
Not at all. Huge backlash. Critics screamed court packing, called it an attack on judicial independence. Even many Democrats and liberal justices opposed it. Chief Justice Hughes publicly pushed back on the efficiency claims.
But the plan ultimately failed, didn't it?
It did. Interestingly, while the debate raged, the court itself started shifting. It began upholding some key New Deal laws, the famous switch in time that saved 9. Plus, a conservative justice retired, allowing FDR an appointment anyway. The political opposition was fierce, and the bill died.
So it shows the risks of a president directly attacking the court structure, even if not defying a specific ruling.
Precisely. It was an attempt to change the court's makeup, not ignore an order. And it failed partly because of the backlash against perceived interference with the judiciary. It also shows how sometimes internal court dynamics can resolve these conflicts.
Okay, so we've seen defiance, wartime exceptions, attempts to reshape the court. What about enforcing a really controversial ruling?
Brown v. Board of Education in 1954 is the landmark example there. The unanimous decision outlawing school segregation faced massive resistance, especially in the South. The court said desegregation should happen with all deliberate speed, but many states just dug in their heels.
Which brings us to Little Rock, Arkansas.
Yes, in 1957, Governor Orville Forbes used the Arkansas National Guard to physically block 9 black students, the Little Rock 9, from entering Central High School. This was in direct defiance of federal court orders based on Brown.
He claimed it was about public order.
That was his public justification, preventing violence. But it was clearly obstructing a federal mandate. President Eisenhower, though maybe personally hesitant about federal intervention in social issues, saw this as a direct challenge to the Constitution and federal law.
And he acted, unlike Jackson.
He did. After talks with Forbes failed, Eisenhower federalized the Arkansas National Guard, put them under his command, and sent in soldiers from the Army's 101st Airborne Division.
Federal troops to enforce a Supreme Court decision against a state governor.
Exactly. The soldiers escorted the Little Rock 9 into the school. It was a powerful demonstration of executive commitment to upholding the court's authority, even when unpopular. A real contrast to Jackson. The court later specifically reinforced its authority in Cooper v. Aaron, directly addressing Little Rock.
These examples really set the stage. Let's turn back to April 2025. Kilmar Abrego Garcia. What are the key facts of his case?
Okay. Mr. Abrego Garcia, 29 years old, lived in Maryland, married to a U.S. citizen, been in the U.S. about 14 years. Critically, back in 2019, an immigration judge granted him withholding of removal to El Salvador.
Meaning he couldn't legally be deported there.
Right. The judge found a clear probability of future persecution if he went back, and that El Salvador couldn't or wouldn't protect him. To get that protection, DHS, the Department of Homeland Security, also had to determine he wasn't a security danger. And importantly, the administration at the time didn't appeal that 2019 decision.
But then, fast forward to March 2025.
He was deported March 15th. Put on a plane to El Salvador with many others. The administration later admitted in court filings this was an administrative error, an oversight, that it violated the 2019 court order.
And what happened when he arrived in El Salvador?
He was immediately imprisoned, reportedly in CCOT, the Center for Terrorism Confinement, known for harsh conditions. He wasn't facing any charges there. There have also been reports suggesting a financial deal between the U.S. and El Salvador regarding detention of deportees.
So, illegal deportation, imprisonment. What happened legally next?
Things moved fast. His lawyers went to court. On April 7th, Judge Paula Sheenis, a federal judge in Maryland, ordered the government to facilitate and effectuate his return. She called the deportation wholly illegal from the moment it happened.
The government did that order?
No, they immediately asked for an emergency stay, trying to pause it. That's what pushed it up to the Supreme Court.
And the Supreme Court's unanimous ruling on April 10th.
They mostly agreed with Judge Sheenis, but with a key tweak. They said, yes, the government must facilitate his release from custody in El Salvador and handle his case properly, as if the illegal deportation never happened.
What?
But they found the word effectuate unclear, possibly going too far in dictating exactly how the return should happen. So they sent that specific point back to Judge Sheenis for clarification, while also saying, courts should generally give deference to the executive branch on foreign policy matters. Crucially, though, the Supreme Court clearly agreed the deportation itself was illegal.
Okay, so the highest court says facilitate his return. But the administration didn't just comply.
No, that's where the current standoff really began. Despite the 9-new ruling, the administration immediately pushed back. Their lawyers told Judge Sheenis it was impractical to even give an update the next day, a claim she flatly rejected.
And they latched onto that word facilitate.
Very much so. They emphasized the Supreme Court's distinction between facilitate and effectuate. The White House press secretary stressed they only had to facilitate, implying maybe a less demanding obligation.
Sort of arguing about definitions while he remained imprisoned?
Essentially, yes. In court and publicly, they seemed to question what facilitate even meant, suggested they weren't sure what steps to take, maybe hinting the order wasn't fully binding. The press secretary even made comments suggesting Judge Sheenis should call the president of El Salvador directly, questioning U.S. court jurisdiction there.
Which seems odd if there's an agreement about detaining deportees.
Right. The DOJ later argued in court that federal courts just can't tell the executive branch what to do in foreign relations.
And what about the reasons for the deportation? Didn't they initially call it an error?
They did. But then the story shifted. Around the same time as the court battles, the administration started loudly repeating claims that Mr. Abrego Garcia was affiliated with the MS-13 gang.
MS-13, which the administration calls a terrorist organization.
This was suddenly presented as the reason he shouldn't be allowed back, shouldn't get court protection. But Mr. Abrego Garcia denies this. He's never been charged. And crucially, it contradicted their own earlier admission of an administrative error.
And it contradicted the basis for his 2019 protection order too, right? That required finding he wasn't a danger.
Exactly. Judge Sheenis had previously dismissed the MS-13 claim as just chatter because it lacked evidence. The administration argued the MS-13 designation itself disqualified him, but legal experts said, well, to revoke his protected status, you'd need to reopen his case and actually prove that affiliation in court.
So in practical terms, what did the administration actually do to facilitate his return after the Supreme Court order?
Based on reports from the court proceedings, very little. Judge Sheenis demanded daily updates. The updates apparently confirmed he was alive and still imprisoned in El Salvador under Salvadoran authority, but consistently said there was no new information on steps being taken to facilitate his return.
Just nothing concrete.
Pretty much. Meanwhile, public statements from the administration and even El Salvador's president suggested he wasn't coming back. This lack of action led his lawyers to ask Judge Sheenis to start contempt proceedings against the government.
It sounds like active resistance.
Huh.
How did other parts of the government react? Congress?
Yeah.
The Justice Department itself?
Well, Judge Sheenis was clearly pushing back hard at the district level, demanding answers, threatening contempt. But the Supreme Court's language, questioning effectuate and mentioning deference on foreign affairs, gave the administration an opening, an ambiguity to exploit.
And they ran with it.
They did. Inside the administration, reports suggested some initial DOJ lawyers wanted to fix the error but were overruled by the White House. The lawyer who first conceded the error was reportedly put on leave. High-level officials were publicly defiant.
And Congress.
Relatively quiet, it seems. Some Democrats sent letters, asked questions, but there wasn't a major unified push from Capitol Hill to force compliance. Republicans were largely silent or echoed the administration's criticism of the courts. Without that strong political pressure, a key check wasn't really functioning.
So the administration could use the legal ambiguity and the lack of political pushback to just not comply.
It appears that way. They created a kind of legalistic justification for inaction, despite the core finding that the deportation was illegal and the unanimous order to facilitate return.
This feels like a really significant moment. And you mentioned earlier the Supreme Court's ruling on presidential immunity from last year might play a role here. Trump v. United States.
Yes, absolutely. That July 2024 decision definitely changed the landscape, and it seems relevant now. It was a 6-3 ruling establishing, really for the first time, significant immunity for former presidents from criminal prosecution for official acts.
How did they define official acts?
They sort of broke it down. First, core constitutional powers, things only the president can do, like pardons, appointments, commander-in-chief duties, even talking to the DOJ. For those, the court said, absolute immunity from prosecution. The reasoning was separation of powers. Courts can't judge actions solely within the president's constitutional domain.
Okay.
A second, outer perimeter official acts. These are things within the president's job, but not core powers. Here, they set a standard of presumptive immunity. Basically, a former president can only be prosecuted if the government proves charging them wouldn't somehow endanger how the executive branch functions. That's a high bar.
And private actions.
Third, they clarified immunity doesn't cover purely private conduct outside of official duties. But, and this is important, the court said lower courts cannot look at a president's motives when deciding if an act was official or private. Just because an act might be illegal doesn't automatically make it unofficial.
So a pretty broad shield for actions taken while president. What was the main justification?
Separation of powers, mainly. And the idea that the threat of future prosecution could chill presidents, make them afraid to take necessary bold actions while in office, they drew parallels to the absolute civil immunity presidents already had.
Okay, so how does that ruling connect to Mr. Abrego Garcia's situation now?
Well, the immunity ruling was about post-presidency criminal liability, but its general tone, the emphasis on protecting presidential action and separation of powers, it seems to have emboldened the current administration. It arguably provides a framework for them to frame their actions here. The deportation, refusing to bring him back as official acts related to immigration and foreign policy. These are areas where the executive branch traditionally has a lot of leeway.
And the Supreme Court even mentioned deference on foreign affairs in the Abrego Garcia order itself.
Exactly. So the administration can argue they're simply defending their constitutional turf, their executive prerogatives, against judicial overreach. The immunity ruling strengthens that kind of argument, at least politically.
And the part about not examining motive.
That could be relevant too. If managing deportations and foreign relations is deemed official, then the administration's shifting reasons first an error, then MS-13 links become harder to challenge legally under the logic of Trump v. U.S. The focus shifts to whether the act itself was official, not why they did it.
So, while not a direct green light for defying court orders, the immunity ruling created a climate where this defiance might seem more defensible to the administration.
That seems to be a reasonable interpretation. It adds another layer to their claims of executive authority clashing with judicial authority.
It's worrying to think how this fits into broader global trends. You mentioned looking at other countries. How does this compare to Democratic backsliding elsewhere?
It's a really important comparison to make. What we're seeing, the executive challenging judicial power, the weakening of checks, definitely echoes patterns in countries where democracy has eroded. Russia, Hungary, Turkey offer some sobering examples.
What were we seeing in Russia?
Under Putin, judicial independence, despite being in the Constitution, has been steadily hollowed out. The executive heavily influences who gets appointed, promoted, or dismissed as a judge, especially higher up. This obviously pressures judges to rule in ways the Kremlin wants.
And law is applied selectively.
Yes, frequently. Targeting political opponents, journalists, activists, while allies often seem above the law. Even Russia's constitutional court has lost much of its power. Plus, there's informal pressure on judges in sensitive cases. Russia shows how an executive can subordinate the judiciary through personnel control and politicizing the law itself.
What about Hungary? Orban's government.
Hungary's path under Viktor Orban since 2010 is maybe more focused on using legal and institutional changes. They pushed through a new constitution, packed a constitutional court with loyalists, they lowered the retirement age for judges, forcing out experienced ones, allowing Orban to appoint replacements.
And centralized control.
Yes, a new national judicial office run by a political appointee got huge power over appointments, budgets, everything. They even tried creating parallel courts for state-related cases, and they've sometimes ignored or slow-walked rulings from Hungarian and EU courts they don't like. Hungary is a key example of using seemingly legal tools to dismantle judicial independence from within.
And Turkey.
Under Erdogan, especially after the 2016 coup attempt, the judiciary has faced immense pressure. There were mass purges, thousands of judges and prosecutors fired or arrested, replaced often by less experienced loyalists.
Constitutional changes, too.
Yes, strengthening presidential power over judicial appointments. High courts became more politicized. The legal system has been widely used against opponents, journalists, activists, and Turkey had also repeatedly defied rulings from the European Court of Human Rights. Turkey shows a more forceful approach, purges, constitutional overhaul, using the courts as a political weapon.
When you lay it out like that, the parallels are concerning. How do those tactics map onto the U.S. situation?
While the U.S. context is different, but you see echoes. The long-running politicization of judicial appointments here is one aspect. You could argue the broad interpretation of immunity in Trump v. U.S. resembles using legal frameworks to expand executive power.
And the defiance in the Abrego Garcia case seems like a direct parallel.
It's the most striking one, yes. Direct defiance of court orders is a tactic seen in those other countries. And while we haven't had purges, the rhetoric attacking judges, dismissing judicial authority, that's been present too. The U.S. isn't Hungary or Turkey, but the current trajectory, especially this open defiance of the Supreme Court, shares worrying features with how judicial checks have been weakened elsewhere.
If this defiance does become normalized, what are the actual long-term risks for the U.S.?
The consequences could be incredibly damaging. First, the legal system itself. If court orders can be ignored, especially by the executive, the authority of all courts erodes. Law becomes less predictable. You move away from the rule of law towards, well, rule by executive decree.
A breakdown of checks and balances.
Exactly, executive supremacy. If the president ignores the courts and Congress doesn't or can't step in effectively, where's the check? It could lead to a real constitutional crisis with no easy off-ramp. And the immunity ruling could, perversely, reinforce this trend by making executive actions seem less challengeable.
And for ordinary people, civil liberties.
That's maybe the biggest danger. Courts are often the last line of defense for individual rights against government overreach. If court orders protecting people can be ignored, all rights become vulnerable. Why bother suing if a win means nothing? Enforcement of rights could become purely political. Long-term, it weakens democratic accountability. It opens the door to a more authoritarian style of government.
This has been a really thorough look at a complex and, frankly, alarming situation. If you had to boil it down, what's the main takeaway?
I think it's the sheer gravity of it. This isn't just politics as usual. A president defying a unanimous Supreme Court order challenges the fundamental structure of American government. We've seen tensions before, yes, but the directness here, especially following the immunity ruling, feels different.
And for listeners just trying to make sense of the news, why is this specific case so important?
Because understanding this crisis is key to understanding where American democracy might be heading. And ultimately, it's about the safeguards for everyone's rights. If the executive isn't bound by law, as interpreted by the courts, then those safeguards are seriously weakened.
So the question we're left with.
What does it really mean for a system built on checks and balances if one branch just refuses that check? What happens if this isn't a one-off, if this becomes the new normal? We have to think about how resilient our constitutional norms really are and what role other institutions and citizens play in upholding the rule of law when it's under direct challenge.
If people want to understand this better, where should they look?
Definitely read up on the historical cases, Worcester, Merriman, FDR's court plan, Little Rock. Understanding that history is vital. Also, digging into the specifics of the Trump v. U.S. immunity decision is important. And looking seriously at what happened in Russia, Hungary, and Turkey provides crucial, if unsettling, context for the potential dangers.
Thanks for listening to Mythos AI. Stay tuned for more concise insights. And remember to hit the like button and subscribe for future episodes.